Hello and good evening. I'm Right Bland. Welcome to my summary of day 41. Yeah, day 41 of the trial of Tamara, Lich, and Chris Barber, the longest running mischief trial in Canadian history. You have paid for this. Your dollars have paid for this, fellow Canadians, for this political prosecution of these two people who decided to have their voices heard and went to Ottawa to protest, as is their charter protected right to do so. Today, finally, it was the defense's turn for closing arguments, and we got in starting with Diane Magus, who's wonderful, for Chris Barber. They are co-accused, but they have separate counsel teams. Diane Magus represents Chris Barber. The whole day was her. Yesterday, I missed it. It was day 40. I'll give you some cold notes summary of it. I wasn't there for it. It was the Crown's continued closing arguments. They did say that they would finish in the day 39. They didn't do that. There was some delays, so I'll give them that. But they took all of day 40 as well. Which is a bit more than the hour or two that they missed on the first day. Nonetheless, these things tend to go a little bit longer than we think they will. If you appreciate these reports, if you like what I'm doing, please like the video, subscribe to the channel, help me grow and spread my message, and leave a comment letting me know what you think. I like to read them. I try to get back to them. We have a pretty good break. The next day of the trial will be day 42 for the continuation of defense closing arguments on Monday at 10:30 a.m. Just has to start a little bit later there. And then I believe we're going also Tuesday next week, and then Friday. Wednesday and Thursday, Defense Counsel has some competing interests, some other affairs. I believe Mr. Greenspan said he had something in federal court. So nonetheless, we begin. And this is going to be kind of more a high level than what I've done recently, as these are mostly focused on legal arguments in the closing arguments. We're not talking about evidence and outrageous, ridiculous things that witnesses are saying, imitating air raid sirens, for the loyal listeners who might remember that from a while ago. And I want to start off this episode by mentioning a friend of mine, Robert Kraychek, and his take from this afternoon, where he said, please remember that essentially all blockages of roads in and around Ottawa, including all but one bridge linking Gatineau to Ottawa, during the Freedom Convoy were imposed by law enforcement. Cops did exactly what the Crown accuses Chris Barber and Tamara Lich of having done. And this is a very, very, very important point that I've touched on numerous times throughout my coverage of this whole fiasco, that the cops made the decision to close the roads. The cops told the trucks where to park and how to get there. The cops blocked those trucks in many cases with Jersey barriers, with public works vehicles like road graders and snowplows and other things, with police cars that were unmanned. And then anytime somebody did want to leave, there was a process to get that approved, go through the chain of command, so on, blah, 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 blah. And they were at times hesitant to do that because they were worried maybe they were going to go further back to Wellington. Who knows? Who knows what the reasoning is? But it wasn't like you snap your finger and then all of a sudden the unmanned vehicle or the Jersey barrier in front of you is going to be removed. Not to mention if you're deep in a crowd of people. So there's all kinds of layers to this. And to lay responsibility for the convoy at the feet of Chris and Tamara is not only wrong, it's not moral, and it's a very dangerous legal precedent, and hopefully one that the court soundly rejects. And before we delve even further into this, some disappointing breaking news expected, and quick, man, it's been like, what, a week or two? The Crown is appealing their loss in Coots against the Coots 2, Coots 4. The jury acquitting the men of the two men, Tony Oleanick and Chris Carbett, of the two most serious charges, the conspiracy to commit murder. They're appealing that. So disgusting. It's like they're going to stop at nothing. These guys have been in jail for over 900 days in remand without services, and very likely the Crown is going to try very hard to keep them there during this appeal process, when they've been convicted of two crimes each, and then Tony has an additional conviction for possession of an explosive. It was some sort of thing at his house, and he operated a quarry mine or a quarry of some sort, so he used it to break up gravel, but they convicted him of having it at his house or something. So they were both convicted of possession of weapons for dangerous purpose, as well as mischief, and then again Tony with the additional charge of conviction for the explosive device, but acquitted of the conspiracy to commit murder of RCMP, which was a big loss for the Crown, and it's no wonder they're appealing it. Now a jury found the two men not guilty of that, so the appeals process is going to be an extremely uphill battle for the Crown. It should be. This is a jury decision. Jury decisions are much harder to appeal in general. I mean, I'm not a lawyer, I'm not a legal professional, I'm not a legal scholar, but jury decisions are harder to appeal. So we'll see how they go about this, and we see what lenience the Crown gives them, knowing that this was a decision reached by a jury. So we'll see how it goes. And you know what? In the interest of justice, the men should be granted bail. So let's continue and dive in to day 4. Oh, quick Coles Note summary, day 40. Day 40, Crown continue to make arguments, ask the court to find Chris and Tamara guilty on all counts as charged. And again, I don't know the exact counts off the top of my head. There's so much information in this trial, as you can imagine, such a wide breadth. And if you want the nitty-gritty details, you can go dive into my X account at any time, the place where the birds sing at Rightbland, and you can go and follow my coverage from the courtroom there as I try to transcribe and report on what's happening in the courtroom. So if that's something you're interested in, you can go and find that. So day 40, the Crown made lots of arguments. Well, you know, you can't. The evidence sucks. So when the Crown flops and makes terrible arguments, it's not entirely their fault. There's nothing to work with because there's nothing there. That's why one of their arguments yesterday was, oh, Tamara and some person had the same hoodie, therefore Tamara is guilty, and so forward. That's all they have. And I think the judge made a comment that, well, it could have been a sale. And apparently somebody told me, she went on to say that, I guess, you know, our book club can't wear matching shirts anymore or something like that. I've seen that reported from somebody, but definitely she definitely said that, you know, it could have been from a sale. So she didn't seem to take that argument with the full weight the Crown wanted assigned to it. As of specific things that I'm going to read from my notes, I'll take a little bit. I'm having a bit of a slow day, but again, I still think that my coverage is the best out there. So please hit that like button and tell me how much you love it, because I know that you do appreciate it, and that's what keeps me going and energized. Literally, I'm saying that as I'm falling asleep. You can see that I'm trying to wake myself up here. So without further ado, let's get into it. So Miss Magus for Chris Barber is addressing systemically what her position is, and she's attacking key concepts like the hold the line thing. And it seems her big argument right now, she said in concerning the charter. So hold on, I'm just trying to find this because I've accidentally undone my notes here, but I'm going to read this. So she brought up a Supreme Court case, and I can't exactly remember the specific citation, but in that case, the Supreme Court found that in cases built on circumstantial evidence, and Magus argued that this is one such case, especially, and the judge, I guess, noted that maybe not on some of the counts, but certainly in the counts it's relevant to. In cases built on circumstantial evidence, the trier of fact must, if there is so the standard of beyond a reasonable doubt in that circumstance of cases built on circumstantial evidence is nearer to absolute certainty than it is a balance of probabilities, and also that if there are other reasonable inferences that can be made, then the trier of fact must find the person not guilty in a circumstantial evidence-based case, as this one is. And so Magus spent the day pointing out different reasonable inferences that could be drawn from the actions of Chris Barber and the words, and spoke extensively about his mens rea in this whole thing, how when he came to Ottawa, first of all, didn't intend to come to Ottawa. It was going to be a regional thing. Then it just escalated and it grew and it grew. But every step of the way, he's trying to work with police. He is demonstratingly trying to work with police. He's running things by them. He parked where he was told to park. At one point, February 8th, I believe, he moves his truck out of Ottawa to exit 88 to a private farmland, tries to encourage other people to go with him, tries to solve different issues. The entire time, his mens rea, he consults lawyers, he consults three prominent politicians, a former premier of Saskatchewan, Brad Wall, I believe, obviously Brian Peckford's only living signatory of the Canadian Constitution Act 1983, was it? The chart, you could say, let me just look it up. Canadian Constitution Act, okay, 1982. Which would have been containing the charter. So that's the overarching name of that piece of legislation, that constitutional law that was introduced and amended on that time. The charter introduced, of course, and he's the only living signature. So he consulted Brian Peckford, he consulted Brad Wall, and he consulted a member of the Saskatchewan Legislative Assembly. I can't remember this, but if you go on my coverage, I did get his name. It was hard to hear what she was trying to say when she was concerning, but he's consulting these people. He's consulting lawyers, trying to maintain his actions in a lawful way. And his mind, his mens rea, is that he's doing something that's lawful, that he has the right to come and protest, and that he's taking actions at every step to maintain the lawful nature of what he's doing. And also Magus talked about the concept of somebody who's morally not morally innocent is not to not find them guilty. If they're there's a better word for it, but that's basically it. If they're morally innocent, then they're not guilty. And then she said that she's going to leave the arguments for the Tremblay case and specifically the 430 subsection 7 defense, the communication of a message, to largely Greenspan and Granger. As they argued, Greenspan was the one who argued Tremblay in 2010, and he did it successfully in the appellate court. So he's going to carry that argument here in this trial court, and I think he's going to do well. But Meg has clarified her approach concerning the charter. So let me just get it, because it's very important. Again, I had it scanned out here, but I've lost it. So she says she's not attacking the criminal code with the charter. I do not need to bring a charter application for purposes I want to use it. And those are two purposes. The first, as in Tremblay 430 section 7, I'm going to leave Greenspan to speak about Tremblay in more detail. They were successfully there. So they argued that successfully. The Court of Appeal agreed. So that's the one aspect of the charter she's going to be using. So we'll hear more about that elaboration from Greenspan at a later time. The other aspect Meg has told the court is for context. Simply to say that people who came to Ottawa to protest, had the right to protest. They're not using the charter to attack the criminal code. They didn't have the right to act in a criminal way, but and as well, our rights have to be maintained in this country. And Magus had some issues with the way the Crown was speaking about the charter and our rights. Specifically, she said some of the Crown's comments with this, such as many people with this length of time becomes unlawful, those comments are displaced. Protest doesn't become unlawful because of the number of participants, and it wasn't unprecedented. It wasn't unprecedented in its length and size, but it was an unprecedented situation with the people from Canada. I believe that this is a paraphrased transcription, but I believe that's what she was saying. It was unprecedented, which is the amount of people just coming from all over the place, people from everywhere. And we heard officer testify. I believe that was it Blonde? Officer Blonde's here. I think he was Blonde, testify that the overpasses were full of people. It was unprecedented in that, and that's part of context, because Crown was suggesting that my client and Lich are guilty because of everyone else who showed up. And she says everyone has the right to show up. No one has the right to act criminal unless the Crown can prove beyond a reasonable doubt my client participated, aided, or abetted these criminal actions. And then the judge added, or encouraged. And then the defense says the Crown has that burden. And exactly, let's remind ourselves. I know I misworded it a little bit. The defense is going to prove that they're innocent. The defense doesn't have to prove anything. The Crown has to prove beyond a reasonable doubt that the accused are guilty, and they have not done that in this case. In my opinion, in so many people's opinions, we'll see what the judge is thinking. But truly, the threshold is high when the circumstantial evidence-based case. If there's other reasonable inferences, the trier of fact must find the person not guilty. And there's a lot of solid legal arguments being made here. And as I said, Magus went through that and then went through the specific examples of things Chris Barber said in text messages, things that he did, and so on, where his mens rea, his mind, was that he's morally innocent, that there are other reasonable inferences other than he's guilty of these criminal offenses. And that she also made another interesting comment. I don't have it highlighted here, but I believe it was something along the lines of, in Canada, the criminal standard is people are evaluated for their individual actions. So if Bob and Ted and Frank and Peter and Sammy and Sally are doing whatever, they need to be evaluated and assessed individually for those actions. It's not on Chris Barber or Tamara Lich for Sammy, Sally, Pat, Peter, whatever. It's them. They're responsible for their actions. And then Magus specifically also attacked this Crown's painting and use of language, that they were standing shoulder to shoulder with protesters physically and metaphorically, especially when it comes to I believe count 7, the obstruct or resist, where the Crown, in their submission, I guess Magus was reading it at one point, said that, and I'm jumping around here chronologically throughout the day, so I hope you can follow along. I know I do my best to give it to you in an interesting and informative way instead of just droning on and sitting here reading my notes to you, because what's the entertainment of that? And what's the point and purpose of that? Our time is valuable. So in any case, at that point, count 7, I believe, resist or obstruct, where the Crown says that even after Barber was arrested on the 17th, he continued through the 18th to the 22nd by standing metaphorically shoulder to shoulder with the protesters. And Magus was basically saying that, how did he do that? There's the video of his arrest. He certainly cooperated. And throughout the protest, Mr. Barber has said, if you do get arrested, put your hands behind your back, take it like a man. And in the video, he says, call my wife. In the video of him getting arrested, he said, put it on social media immediately. And then Magus says a reasonable inference of putting it on social media is to show people that if you get arrested, comply. So Seriously. And at a different point, Magus said, the Crown has everything. The Crown has my client's cell phones, and then she named the exact word for the police or intelligence extraction of the phone. They have the police extraction of the phones. They have all this, and this is the worst that they have. You know, we don't see him. This is the worst. This is it. So where did they prove that on the 18th and the 22nd, you know, Barber is standing shoulder to shoulder, resisting and obstructing police, aiding and abetting people, standing and physically whatever, doing anything. Then there was the hold the line comments. So basically, we went back and forth on some of that. The defense was trying to say that when Barber says hold the line to him, it means, you know, stay. It could mean a bunch of things: stay peaceful, don't give up, and all this. The judge basically disagreed. The judge said, well, it could mean stay true to your beliefs, or sometimes physically hold the line. The judge brought up an example of the SQ pushing against protesters, where they weren't quite pushing each other, but both of them, the police and the protesters, were saying hold the line. In that case, could be physical meaning. But again, Barber said it. I think the defense said he said it in his videos 4 times, and in each time there's different meanings of it. So they or 4 examples of times he said it. I don't know, one or the other. You can go through my notes and get it. I think I got that accurate. But he said, you know, there's 4 examples of this going either way, and you know, he's never telling people to go physically obstruct police on the street. You know, why would he be consulting Brian Peckford? And the defense brought up a video of him and Brian Peckford talking about the charter and holding the line, and then the defense is like, surely you're not suggesting that Brian Peckford and my client are saying, you know, surely the Crown isn't suggesting that my client and Brian Peckford here are saying go out and obstruct and police physically, and they were talking about the charter. So the judge said, well, surely, you know, they're talking about being strong with your beliefs and holding on to your beliefs because they're talking about the charter. So there's definitely a lot of nuances, and the point being, it's death by 1,000 cuts, right? The defense are tearing everything apart, and if there's reasonable inferences that mean other things besides guilt, then the trier of fact must find the accused not guilty in a circumstantially evidence-based case. I don't have any liquid. I was just about to take a drink of this. This is how crazy I am. I have no more liquid left to drink. I'm not going to try to drone on about this because, again, it's heavy stuff. There's a lot of examples given. We go over text messages that Barber had with Officer Bach, who was his primary assigned PLT officer, some text messages. I think he had one exchange with Officer Sear, and then maybe something with Blonde, but mostly with Botch. And then the defense made a note of pointing out their client's actions, Mr. Barber's actions on other day, like when constantly talking to Botch, constantly telling, okay, we have issues here, we have this is happening, and the idea of slow rolls, that Barber wanted to move towards slow rolls, and that Botch had actually said, yeah, slow roll Parliament every day. It'd be, you know, that it'd be, you know, it'd have an impact, but it would provide some relief to the citizens of Ottawa, and that's something that Barber, you know, had actually gone to people talking about Exit 88, the farm, going there, and he himself led by example on the 8th and relocated there, his big red off of Wellington, and it just goes to show that he's not the king of the convoy. He's asking people, he's showing people, and in one video, I think it was from February 2nd, I don't remember, I'm sorry, Miss Magus and everybody else, it's all over the place, my memory's not the greatest, but there was a video, I believe, presented earlier than February 8th where, and this was an interesting point between everybody, where Mr. Barber says, you know, he's at the place off Exit 88. He said, we have so much space here. You can come here. You can't imagine. We have everything. There's food. There's whatever. You come here. If you don't have if you're in Ottawa, or he says something for trucks who are parked, who don't have a plan or a place to go, come here. And then at the end of the video, he says something closer to, if you're outside of Ottawa trying to come to Ottawa, come here. And at first, the judge, you know, the defense had a position saying that Barber was saying to people downtown, come here. And then the judge said, well, no, actually, he said, if you're not in Ottawa yet, come here. But we re-listened to the video, and he said both. At the end, he says, if you're outside of Ottawa, you don't have a place to go, come here. But he also says, if you are parked in a truck and you don't, at the beginning, if you're parked in a truck and you don't have a place to go, come here. And then the defense argues a reasonable inference is he's talking to people downtown. If you're downtown, you don't have a place to go, you don't have food, you don't have money, you don't have a shower, you don't have a place, you don't like sleep, come here. And again, he's not the king of the convoy. He can only do so much. And the defense also focused on the fact that he does not have a positive obligation, a positive duty, a duty to command people, to get them to move, but he's still trying to do that. And that goes to his mens rea, his lack of the guilty mind, his moral innocence. And this is all, again, reasonable inferences other than guilt. And I think this is a very strong defense. We're dealing with very competent defense counsel. And Miss Magus joked that this is the second time that she's ever had to use a PowerPoint demonstration in her 30 years of practice, I think she said. And she said there's a comment about the modern times. I think the judge said something, this is a comment about the modern times, and then Magus responded again in joke. And of course, it's always respectful between the counsel and the court that we're not going to comment about that. And there, speaking of jokes, there was another joke at another point where they were talking about, hold the line again. And I believe Magus said something about party line systems, or, if you were on the line and then the operator would have to hold that line. And then the judge said something about that being before her time. And then Magus said, I don't think it is. And then the whole court laughed, and it wasn't rude. The judge took it in great humor. It wasn't an offensive joke at all. But I think they were talking about like party lines, when you had the operator hold the line for you as they were balancing, the 8 different calls in your region that can be handled at the same time. So yes, overall, the defense doing great, saying that, the charter in this case, there's going to be the 430 sub 7 argument from Tremblay, that the people who actually argued Tremblay, Lawrence Greenspun and Eric Granger, I don't know if Granger was there, but certainly the two of them will be arguing that. They will take the reins on that, and Megan said she will mostly adopt that, as well as their position on the Carter application, as it's most relevant to their client, Ms. Tamara Lich. So that's going to be their focus, and that's going to be very heavy legally. When when Mr. Granger gets up, that you're about to be hit with about 40 or 50 different pieces of case law in a very timely and punctual way, and they're all going to be tied together in a very nice little bow. But you better be paying attention, because he's not going to say it twice, and he doesn't skip a beat, and he's very clear. But it is heavy stuff, and I believe the judge appreciates his submissions the most, because it's just, here's the law, here's how it applies, and it's very, very concise. And when you're talking about, law isn't a science, but when you're talking about like an argument, a verbal argument, a debate, and you have somebody who can present that way, it is a fantastic thing for whoever's hired that person. And then Greenspun, brings it home. He brings it home. He gets up. He takes the arguments that are on the floor. He takes any loose ends. He ties them. He's the guy who's on his feet. He's the guy who pivots and positions himself to deal with any loose ends and any outstanding questions. And he's the one who really firmly communicates the message. It's a 1-2 kind of combo, and it works well. It works really, really, really well. I mean, they could both do either one, but yeah. And Magus is phenomenal herself. Like I said, she's saying, this is a case built on circumstantial evidence. The Supreme Court found, and again, I'm sorry I forgot, I did not catch the exact case they're citing, but the Supreme Court found that in that circumstance, that if there's other reasonable inferences, the trier of fact must find the person not guilty. And there's tons of reasonable inferences here from all the different examples that were presented today and throughout the trial. And of course, also, Magus asked the court to consider the lack of evidence. This is the worst they have. They have the cell phone extractions. They have her client's, Mr. Barber's cell phone, and this is all they have. I think we can leave it there, guys. I think that's a pretty good high-level summary. It's always a pleasure to be able to do these for you, and thank you again. Like the video. Let me know what you're thinking about things. Leave a comment. Subscribe to my channel. Share it with your friends who are interested in the state of our country, the freedom of our country. And let's remember that these cases have such phenomenal and wide-reaching implications. I want to say especially, but including for the people who hate these accused individuals, because if this ends in such a way where our rights are eroded even more, that's going to affect every protester going forward, anyone who has a cause, anyone who has a disagreement with any government. It could be a Poilievre government in a year, and you might want to protest that. You might hate Tamara Lich and Chris Barber. Well, you might find some of the legal precedents set during the Freedom Convoy really coming in to kick you where the sun don't shine. And that's just to say that this is going to hurt all Canadians. We need to maintain our rights no matter who they concern. They are very important. And there is such a balance to be done here between the criminal side of the law and our rights and freedoms. And of course, the Crown keeps saying you can't consider everything in a vacuum, but what about the circumstances we all found ourselves in 2020 and 2023 between those years? They were terrible. We were living in unspeakable, let's not get into it, but you remember. So thank goodness for the Freedom Convoy, and thank for goodness for, and all the people who came in a truly grassroots movement to stand up and have their voices heard in a peaceful way. They were not violent. They were not violent. I think with that, I'm going to sign off. Thank you for listening. As always, from Ottawa, I'm Right Blend. I'll see you next time.